Andrew Benyon, Joanne Green, and Carl Schock. Thank you for coming back to be with us today to answer questions, and we're going to get started right away with questions, going to Ms. Troupe first.
7 minutes.
For 7 minutes. Okay.
Okay, sorry. I didn't know if they were speaking. There's been a lot of consultation done on this bill, on S2. Could you state for the record the number of meetings that have been held with First Nations on this topic, and the ones that were held across the country? Could you give me some examples of some of the places that the consultations were held?
Madam Chair, I'll start with that, and if my colleagues find I need to be corrected or any addition, they'll do so.
Great, thank you.
Just to start maybe a little farther back, studies and focus group sessions and information sessions were held starting back in 2000 concerning the issue of matrimonial real property on reserve. And the actual preliminary planning for the consultation process started with the Native Associations Women of Canada, sorry, I'm a little nervous, and the Assembly of First Nation. From that, when the consultation process, national consultation process started in 2006, there was held 103 sessions at 76 locations across Canada. A lot of them were held regionally, with meetings held at different locations such as Fredericton, Quebec City, Thunder Bay, some in Ontario. Those are just to name a few of the places that were held, some of the sessions that were held there. And part of the consultations for participating, the Assembly First Nations and the Native Women's Association of Canada each received $2.7 million for the participation in the consultation process. Overall, $8 million was spent on the process, and Canada Aboriginal Affairs spent over $2.8 on that process as well, as part of that $8 million, part of the consultation process that took place.
2.8 was part of the 8. So you said that, sorry, the 2.8 was part of that 8 million?
Yes.
Yes, okay.
Yes. Madam Chair, that was part of that 8. Wasn't sure.
Sorry, are you looking up something, or you finished your answer?
Just to go on, if you wanted a little bit more information on some of that. So part of the consultation process included 4 phases, which is the planning, the national consultation, and also consensus seeking or consensus building, and also engagement on draft legislation.
Sorry, can you just describe that consensus seeking? What is that?
The consensus-seeking process was a process facilitated by the ministerial representative for trying to seek consensus on what the content of the legislation may contain. And there was, during those processes and the engagement process on the draft legislation, the parties all had the opportunity to provide their input into what the legislation would appear. So, for instance, some of the comments were received on restructuring the bill from the Native Women's Association of Canada and Assembly of First Nations that would focus the elements on the family home and create new concepts and definitions rather than real property. They thought that might be an issue. A change in title also was recommended by from originally it was going to be called Family Homes on Reserves and Matrimony Interest Rights Act now, but was going to be called Matrimony Real Property or Removables Act. And they suggested that might be a little bit problematic given the different kinds of ownership on reserve, and so they suggested that the new title, that is currently the title, as part of that consultations. And the definition of family home. And one of the issues they really wanted to stress is for greater certainty, which is reflected in the legislation in Clause 5, the for greater certainty clause. It reflects there that it clearly states that the title to the lands does not change or does not change the status of reserved lands.
Great, thank you. What level of participation did the provinces and territories have during the creation of this bill?
The provinces were engaged in the consultation processes. There was individual sessions held, and they could provide comments. There's also group conference calls held where they could provide input and information on.
With all the provinces?
Yes,
Okay.
with all the provinces took part in that.
How many written submissions were requested, and how many did you receive?
Well, we didn't request necessarily any written submissions. However, the three parties, AFN, Aboriginal Affairs, and the Native Women's Association of Canada, had available during the consultation times a 1-800 number. They also had email address and also an address where they could provide written submissions or comments should they choose to. So anyone across Canada was able to provide comment to any of the parties through those means.
How will the Centre, I understand what the Centre of Excellence is, but how will the Centre of Excellence support First Nations who are developing their own legislation on the topic of on-reserve matrimonial rights, property rights?
So the Centre of Excellence is planned, because of course that's pending appropriate funding approvals, is planned to support First Nations through providing information, tools and communications and best practices related to the development and of matrimonial real property laws, as well as should they choose not to develop their own First Nation law, to help probably understand the provisions that are in Bill S2, to have a better understanding of those as well. The Centre of Excellence it's a plan to be established within an existing organization that is at arm's length from the government and the First Nations that it intends to serve.
So at arm's length from government and First Nations?
Yes.
Okay.
Yes.
So, time's up? Okay.
I'm going on to Nikki.
Thank you very much. I'm wondering, first off, how many consultations were held on Bill S2? So not the predecessors, but on Bill S2, which I understand was presented in December 1st of 2011.
So, Madam Chair, to address that, we have had ongoing discussions with First Nation organizations, First Nation groups, and representatives since the introduction, pretty well, of the legislation back in 2008. And we heard from testimony from witnesses, committee, the Standing Senate Committee on Human Rights.
So maybe if we could get the information on what actual public events took place, these consultations you're referencing since December 1st, 2011, in this Parliament. I mean, that's really what we're looking for. If you could provide the committee with that information, that would be very, very helpful. Now, going back to the previous round of meetings, we note that in the report of the ministerial representative, it was pointed out that the timelines were often viewed as too short, not allowing time to review and properly understand the complexities of the issue. Some participants felt that Indian Affairs should have gone directly to individual community members, and that information should have been more readily available to everyone and not just disseminated via the internet. I want to also pause on that piece as somebody who represents 33 First Nations in Manitoba. 18 of them are isolated. Many of them do not have the kind of internet service, let alone other services that we benefit from in urban centers. This poses some real problems, and the fact that this was expressed and is in the report is an indication of how obviously many people felt about this consultation. Now, I'm wondering, just moving to the recommendations made by the ministerial representative. We hear about the 30 recommendations. My question is, what happened to the other 3 recommendations that were not brought forward?
Perhaps I could just say, just whilst my colleague is looking that up, Madam Chair, the request for some details on the exact consultations that the member asked for, we would be prepared to share with the committee a list that provides information on the consultation sessions held before the formulation of S2 and afterwards too.
Sure, and thank you for that. And again, and we're keen to have real timelines on that, sort of before and after. I mean, S2 is not S4; it's S2, right? So we'd like to get that information. But I'm wondering. I mean, those 3 recommendations that weren't adhered to were very critical. If you're not able to answer, I mean, I'll just move on to my next question.
The response to that, Madam Chair, there was 3 of the 33 legislative initiatives, that recommendations that aren't directly related in the bill. One was the title, which I already spoke to earlier, and that was the title that we have now that was referred to by the AFN recommendation for the title that it does now have. The other recommendation, inherent jurisdiction, feels that wasn't addressed because there's provisions for negotiating self-government agreement. And I forget what that was. Sorry.
The other recommendation, if I may, Madam Chair, was the inclusion of a provision of review of the bill after a certain period of time. That was not in the bill.
How about the piece around the non-legislative measures, which is obviously a real concern around costs incurred to the bans, to the legal systems, the fact that we're not dealing with, and there's about 40 women's shelters across the country on reserve, out of 600 and some First Nations, obviously completely inadequate. This bill has nothing to do with that. And we're very concerned that obviously a number of First Nations and stakeholders raised real concern about how, S2 will simply not end violence against women when all of these other matters are not being dealt with and the investments aren't being made by the federal government. I'm wondering, why aren't the non-legislative measures, which are critical, being addressed at all?
Maybe I would start the answer to that by saying, with the Center of Excellence that was referred to earlier, we have to consider after the legislation, if it is adopted by Parliament, how the Center of Excellence will be set up and exactly what the funding level will be. But I would just share with the committee that in the proposals that have been published so far inviting Aboriginal institutions or organizations to consider becoming the Center of Excellence if the legislation is passed, the public documents identified a maximum potential funding of approximately $4.8 million over a period of 5 years. Now that's subject to, again, the legislation being passed and subject to Treasury Board approval of the level of funding if the legislation is passed. But it gives a sense of the investment. The other area that I would flag for committee members' consideration is that in our implementation planning, there is consideration of some funding for RCMP and for the Department of Public Safety to assist in advancing the legislation and interactions with the provinces. I will say I understand the point that the member is making about the broad range of issues that really are at stake. There's housing issues, there's women's shelters issues, there's improving schools issues. There are many issues, and on that front, I can only say that these are some of the implementation investments. Those other issues, I think, are a point that the committee can consider and make recommendations on. But the legislation itself, Bill S2, we did not choose to put right in the provisions of it issues around implementation like the funding of women's shelters.
Madam Chair, how long do I have?
Time's at 7. Okay, moving right along to Ms. Young.
I'd just like to thank you for being here today. And I'm going to ask you a set of very quick questions because I find that this is such a very, very important critical issue, but we're sort of lacking some fundamental grounding data. So if you can supply that to me, and I think that within yourselves you'd know, who should answer. And then after that, I'd like to ask some more broader questions. First of all, we know that there are some 600 First Nations bands. How many of them have already enacted matrimonial property rights legislation? And if so, which have done it under the First Nations Land Management Act and which has done it through self-government agreements?
We could provide very precise figures, but I'll just give you a quick sense of the answer. Self-government, First Nations that operate under self-government provisions have that authority to cover matrimonial real property. They're not subject to this. First Nations Land Management Act provides for authority of First Nations to adopt their own matrimonial real property laws, and the First Nations land management regime is expanding. A lot of First Nations are expressing an interest in opting into that legislation. As I recall, the figure most recently was 22 First Nations having moved to the stage of having adopted matrimonial real property laws under FNLM. And I know personally that there is a lot of work amongst other FNLM First Nations to move to adopting their own matrimonial real property laws.
So in other words, this legislation is existing, has happened in 22 First Nations. So we are, in fact, dragging the other ones or providing women and children at risk, in violent situations and bringing them into the 21st century. Is that correct?
Yes, I would agree that there is experience amongst FNLM First Nations, for example, with matrimonial real property laws, and I would fully expect that the Center of Excellence in going forward would look at the provisional federal rules, examples of matrimonial real property laws, including those developed already by FNLM First Nations.
Now, we talked about a lot yesterday about violence against women and children in the home, and that's why the exclusion, the emergency orders are so important that is part of S2. But nobody has bandied about any figures in terms of how much violence there is. I mean, I think that the minister said something about 19%, which is 3 times the amount that regular other non-First Nations situations have. So that I would think is quite a bit, 3 times the amount of violence against women and children, and obviously we know that emergency orders protects lives. So do we know how many deaths there has been in this area and what we're anticipating in terms of saving lives once S2 is enacted?
If I can just provide a little bit of background to that, there has been studies done, so I don't have specific figures on that. We do have available a summary of a report that does provide some of situations, a summary of how situations where the emergency protection orders would have assisted those women and men that were in peril or having domestic violence. Would have helped probably de-escalate the situation. One of the important parts of the emergency protection orders is that it provides for up to 90 days on an immediate basis for exclusive occupation on application. And in a conversation with managers from Alberta for First Nations shelters, one of the attendees was excited to hear about that and questioned if it could be extended, because in their community, their approach was holistic, that they worked with the offender and the family to try and rehabilitate the family, and she was hoping that sometimes it takes longer than the 90 days and that could extension be sought. And that is provided for as well. In the Senate, the amendment provided that it can now be up to discretion for the extension or changing of the order beyond the 90 days. Originally, before the bill, it was just additional 90 days for a total of 180.
Right.
So now a judge has a discretion to extend that beyond. So that would probably address in that community, if they made representation, they might be able to extend it beyond that. So
now, beyond the safety aspects, which you've just given us, thank you so much. I used to sit on the YWCA board in Vancouver, and we actually built residential housing for these situations for these women that had to be sheltered. So I wanted to just say that, I mean, obviously you've mentioned studies, research, and we've heard about the testimony that has been given regarding women who wanted to stay in their homes. Would you say that it's a better model, for women and children to stay in their homes as opposed to being, sent off to shelters?
Also as a First Nation person, but also it's important, I think, for children and women who have their support system within a system in the community to be able to maintain that in their community and connection to their culture. And there's been a study done quite a few years ago, but there's a study that found that it would be better to have emergency protection orders available in all provincial and territorial family law, because they do provide such an important protection to help de-escalate in some instances, potentially even avoid criminal charges if it can be done in a time to avoid the escalation of the family violence.
Right. And given the... Oh, sorry, go ahead. Quick answer.
A very quick answer. I think the point for the committee to consider is, as I think you alluded earlier, this is a question of a legislative gap. So the legislation would not, if it were to be adopted, would not say women and children have to stay in the matrimonial home on reserve. It just creates a different option.
Right.
Some may want to go to emergency shelters in Vancouver or elsewhere, but right now the problem is that option doesn't exist as something that the courts can enforce.
Which other women have.
Which other women in other communities have a different set of options.
Exactly. Thank you.
Okay. Moving right along to Ms. Bennett.
Thank you very much. As you know, there's still some serious objections to this bill from First Nations communities, and a lot of it is really, in the words of Wendy Grant-John herself, that the viability and effectiveness of any legislative framework will also depend on the necessary financial resources made available for the implementation of non-legislative measures. So I guess I would like to know, does the department have an action plan noting what, by when, and how those supports would be in place?
The implementation plan unfolds out in stages, of course, because with the amendment, the changes to Bill S2 before it was introduced, with the addition of the 12 months transition period, the provisional federal rules within the Act don't come into force until a year after the first part of the bill, which is the First Nation lawmaking mechanism, comes into force by order in council. So right off, there's 3 parts to the implementation plan. It's an awareness campaign, communication awareness campaign. The second part is the establishment and maintenance of a Centre of Excellence over a 5-year program at this point, which we talked about earlier. And then the other part is training and education for frontline officials and officers, which includes training through the RCMP in public safety for the policing, and education for Superior Court judges, because it's Superior Court judges are the level at which the provisional federal rules have ability to be addressed in, because they deal with also divorce law. So part of that in that. So the stage would be there's intended to have regulations to help court procedures related to emergency protection orders. We've already had some engagement sessions on potential regulations with provinces and territories. That will be conducted. Another session will be conducted in the development of that, and they are to be in place, of course, by time the second part of the bill comes in force, the provisional federal rules part of the legislation. So through that time also, the Centre of Excellence will be operating to assist First Nations as that part of it comes in force with the Order of Council, and to provide also information and support, as we talked about earlier.
What's the budget, and is the awareness program begun, and the training? And what's the budget for that? There's no real reason you have to wait for the legislation to do an awareness program or the training.
Well, I've always been available doing all kinds of information sessions and awareness. We have continued to provide.
But in terms of a real strategy of what, by when, and how, what's the budget for those two pieces, as well as what would be the budget for the Centre of Excellence? It's not in this year's budget, that's for sure.
Right. We have to respect the decisions by Parliament. We have taken some steps as a department to try to disclose as much information as we can about the proposed legislation.
No, but in terms of the awareness program and the training, you don't need legislation for that. That is actually, women are still dying by intimate partners.
I understand.
There isn't the shelter space. Yeah. Everyone's saying that this legislation won't fix the problem.
Well, if I may, I think the answer is we do have to respect Parliament in terms of moving too fast on how we're implementing the legislation.
No. We're talking about the complementary, non-legislative things that are the big objections to this bill. That people want to see those things in place.
I understand, and if I may, I would say this. Yes, we have worked on a draft implementation plan. We have provided for the public notification of the level of funding proposed for the Centre of Excellence.
Could you table the draft implementation plan and the budget that you would suggest?
Yes, I think we would be prepared to do that. Again, it's subject to final Treasury Board approval.
Okay.
If I could also just say for the record, though, Wendy Grant-John has made some very good points about the importance of implementation of legislation, not just what legislation says.
But let me, if I may, she also said a minimal role for federal legislation, minimal role, and a virtual universal opposition to the introduction of provincial laws by incorporating them into federal law to deal with this issue. She actually said the strong preference was for First Nations jurisdiction to fill the legislative gap. And, I think that we are concerned that the National Centre for First Nations Governance had its funding totally cut. And now we have to wait for a Centre of Excellence while there's no real ability or budget for First Nations to fill this legislative gap without resources.
Okay. On the point about the First Nations Lawmaking Authority, I would just say I think that committee members need to consider the balancing act that has been created here. It is different from what Wendy Grant-John has recommended, but there's a mechanism here where First Nations can entirely displace the provisional federal rules without this legislation dictating to them what they must put into the matrimonial real property laws. And I think it is for committee members to consider if that strikes the right balance between the federal government taking some action to address a gap and respecting the authority of First Nations themselves to make their own rules on a different basis, which I think is consistent with what Wendy Grant-John raised. Again, for the record, I would say, yes, Wendy Grant-John is right on the point about implementation. If this legislation is enacted, to be effective, we have to all look very carefully at the level of investment. So far, what's public is the proposed $4.8 million for the Centre of Excellence.
Okay. The AFN has asked that the transitional period needs to be at least 3 years, right? Is that I guess we have to ask the government members if that's something that they'd be prepared to consider.
Just to address that, there were other parties that asked for the transition period as well. The transition period is at 12 months because it strikes a balance, respecting the idea that some First Nations are preparing to enact their matrimonial real property laws and not choosing to ever have the effect of the provisional federal rules. Of course, First Nations can enact their own laws under the bill at any time after it comes in force, not just within the first year.
Okay.
And,
Thank you.
Was it time? Oh, sorry.
Thank you.
Time? Okay, sorry.
Ms. Crockett?
5 minutes.
Oh, 5 minutes. 5 minutes
Yeah,
this
I
time.
very much appreciate you being here and the candid answers. I think we're getting a very good picture of the underpinnings to this bill, and I appreciate that very much. So what I'm hearing is that the Center of Excellence does have a projected budget of almost $5 million over 5 years, substantial, and that it will be arm's length from government, so it won't be controlled specifically by government, and that there will be a good opportunity for information, tools, and best practices to be shared without government dictating. Is that correct?
Yes, and I would just add as well, the focus is on working with an existing Aboriginal institution so that they've got some capacity to start. Yes, there's a one-year transition period, so there'll be time for the Centre of Excellence to prepare, but it's not starting from zero with an organization that's not used to providing services and using a website and providing information. We're trying to rely on and build on some of the existing expertise of an institution.
And we've heard quite a bit about the consultation, but I just wanted to talk a bit more about that because I think it is important that we fully understand how much. So there was $8 million spent on consultation, 103 communities, ASWAC was consulted, and we've talked about Wendy Grant John. Now, I gather that she issued 33 recommendations. Can you tell us how many of those were accepted?
Altogether, there was actually more like 64, but the specific to the legislation, solutions or contents of the legislation, there was 33 from the analysis taken, and all 30 of those are represented. For instance, the best interest of the child is considered. That's also in the preamble, and it's when you're considering, the court is considering considerations, a whole sets of criteria related to emergency protection orders as well as exclusive occupation of the family home. Mm-hmm. The best interests of the children are to be considered, and that speaks back again to their ability to maintain a connection to their community and things like that. So that's all part of one of the considerations. The main, one of the important ones. Yeah. Children are important.
And so did I hear you say 30 of her 33 recommendations were all accepted?
Yes, and the three were spoken to earlier. They were addressed in other manners.
They were?
Yeah.
Excellent. Now, can you just tell us on the ground, how are these emergency protection orders actually carried out? Is it going to be a complex process, a simple process? How will lives actually change for women on reserves who are in the middle of a family violence situation, given that there will be emergency protection orders provided through this legislation? Thank you.
So I'll start, if I may, Madam Chair, and then one of the things that is really important, I find, and in a bit of a personal level for this, is that the bill, in the legislation itself, it provides for a police officer and another person to be able to, and it is intended that regulations will support that it can be another person that can apply on behalf of a person or applicant. So if that person is unable to make it, another person could. So, for instance, in my community, there was a young woman who was denied access to see her mother, and 2 weeks later she was beaten to death by her partner. Had the emergency regulations been available, it's possible she could have been worried she might have been able to apply on behalf. The court could have given her permission to do so, to have the partner removed, to prevent that. So in that instance, I think that's one of the ways with the combination, it's procedural. So most of the provinces only currently now, because BC just had in March, had their new family law come into force. That includes now emergency protection orders.
That may have been a life a life saved right there.
Yes, there may be potential for that, yes.
Thank you for sharing that with us.
So if I can just add to what Joanne said, in most provinces, the courts and the police and so on are already familiar with emergency protection orders, and as the concept implies, it's an emergency response, so you deal with it very quickly. And this legislation would extend a very similar authority to on-reserve situations. So it's something that, for the most part, the provincial authorities, provincial police are familiar with. The funding and the work with public safety and RCMP would be oriented to trying to make sure that there is the right training on this federal legislation.
10 seconds.
My 10 seconds. So previously, they would not have been able to apply for that. What would have happened to the women and children, just briefly?
Quite often, in response to that, they end up having to leave the community, often with the children, and often usually going to urban centers or whatever they can, leaving their support systems and their home. And quite often,
Night packing up the belongings and rushing out of the house in crisis.
often, and we've heard from
Thank
a woman
you.
that said that. Oh, sorry.
Sorry. Okay, Ms. Cratter and Ms. Day?
I'm sharing my time, so Madam Chair, if you wouldn't mind letting me know when 2.5 minutes is up. Because I only have 2.5 minutes, I'm going to pose my questions and ask if you could submit your answers in writing. Mr. Jacques, the other day I posed a question on whether the Section 35 analysis had been done on this bill, and you indicated that information had been provided to Cabinet that was confidential. But I wonder if you could tell us what factors are considered broadly in the Section 35 analysis, and if you could provide that in writing, I would appreciate it. With regards to the provincial consultations, you indicated, Ms. Green, that the provincial consultations had taken place with every province and territory, I presume, because I guess not in territories because there's no reserves there.
Yeah, just the Northwest Territories has.
Yeah, just the Northwest Territories. So consultations took place with every province and territory where it was applicable. I wonder if you could provide in writing to us what specific concerns the provinces and territories raised and how they were specifically addressed in the legislation, and whether or not discussions took place on the complex land codes that exist on reserve. This has come up under wills and estates, as you're probably quite familiar with. The third question I had was with regards to analysis of implementation cost that could be borne by the First Nations and the province, because there will be costs for the provinces. And my fourth question, and if I have any time left, this is the one I would appreciate you could speak on. People keep talking about violence against Aboriginal women and children as being part of this bill, and it is mentioned actually 8 times in the legislation, and I won't quote the particular sections. I'm sure you're quite familiar with that. But I wonder if you could specifically talk about what specific measures, other than what's outlined in the bill with regards to emergency protection orders, will be undertaken to combat violence against Aboriginal women and children. And if this is the one you could start with, how do you see the enforcement of emergency protection orders happening in rural and remote reserves, which are already underserved by enforcement officers? So if you could start with the protection that on rural and remote reserves.
15 seconds.
Otherwise, in writing.
It's okay. I was just going to say it's intended that through the regulations that they're able to apply by fax, email, and telephone, and they can be replied to under those same methods and granted through that same method. Sorry.
Bonjour, je vous remercie d'être revenu parmi nous. Alors,
good afternoon. I'm welcome back. There was a press communique published by the Aboriginal women's of S2 that want to maintain the S2 insofar as the matrimonial aspects, and the chair said that it would not be in conformity with the laws in civil law in the province of Quebec in case of separation or death of the person, and 40% of the common law families, it affects them. So my question deals basically to Mr. Jacques and to the Department of Justice. Did you do an analysis on the differences on the application of the provisions of S2 in the province of Quebec, because they do not have the same legal system? And in the same information, have there been any impact studies of S2 dealing with Quebec to see any kind of possible legal fraud or deviation there? Thank you very much. Yes, thank you. Just to pick up what the honourable member has just said, one of the recommendations from the ministerial, from the department, was the corporations and provincial laws have been excluded. Now, to having a plan applicable to all, there will be difference that will occur between one province and another. So the differences of the province of Quebec, as well as with Ontario or any other of the other provinces, they do not have a similar system in all the provinces. And by setting up a new system, there will be differentiations. There is no legal opinion here in this case. Well, one must say that provincial laws continue to apply in sharing of personal goods, taking care of children, family allowances, etc. The only difference is the sharing of the family home and the real goods. That's the only differentiation between one and the other. Thank you.
Ms. James.
Thank you, Madam Chair, and welcome back to our three guests today. One of my colleagues touched base on, I think the question had to do with how many First Nations had already enacted matrimonial property rights legislation. And I believe that you said, I wrote it down, 22 through the First Nations Land Management Act. But I didn't actually hear if there was any type of outcome of that type of legislation, whether there's been any positive effects from that legislation going forward of those 22 that have already enacted their own matrimonial property rights legislation. I'm just wondering if you can touch base on whether you have any sort of statistics or any positive feedback or any things that we can note down that would point to the fact that how important this type of legislation is actually. Thank you.
Thank you. We don't necessarily have any statistics. The First Nation Land Management Act does not require that a copy of the matrimonial real property law be provided to the minister. But we have, in conversations with the First Nation Land Management Lands Resource Center, been assured that for the most part, the matrimonial real property laws have been working well within the communities because they are community design and driven. And there hasn't been, I don't think, very many appeals to those provisions that they developed, is my understanding. There may have been the odd exception, but I'm sorry, I don't have the statistics on that or what they are, but my understanding is that they seem to be working quite well.
Okay, thank you very much. I just wanted to ask you a question. I know that it's come up in discussions, whether it be in the House or outside, just with friends or family or whatever else. But is it possible through this legislation for someone who's a non-member to actually obtain and have property transferred to them permanently? Is that? I just want to get a clear answer on that because I'm pretty sure I know the answer on that. But again, I've heard some things out there that would imply that, for example, someone like myself could end up owning property, and I don't think that's the case. So if you could clarify that, please.
No, there's no transfer possible if a person is a non-member.
But if they're a non-member and they're in a situation where they've had to have emergency protection orders, do they have a right at that particular moment to remain in the property with their child or whatever else? If you could please explain that and for what period of time that might be.
If they do have an emergency protection order, they would have the period of time for the emergency that the judge would have attributed. And they can also apply for exclusive occupation if there's a breakdown of the marriage. at that period would be because the marriage or the relationship is terminated, and then they could apply to stay in the home for a definitive period determined by the judge with the children or whatever the judge or circumstances would call for. The Act sets out the circumstances that the judge might take into account to provide for the period of time and whether or not occupancy should be given. But the one aspect that was amended actually in the Senate was to take into account the relationship of the person to the community. So if it's a perfect stranger, that would obviously play in the balance as to what period of time the person would be allocated time to stay in the house.
But under no circumstance would someone like myself be able to have property transferred into my name, and I would be the
Act sets out transfer only between members as possible.
Thank you. I just wanted to clarify that. Now, there's been some criticism of this particular legislation that it has not taken into account First Nations culture or traditions. What do you say to people who come up with that type of an argument?
I believe that there is a complex issue related to balancing the collective interests and providing basic rights and protections to individuals on reserve. And we have been very careful, as one of the recommendations by the ministerial rep, to try and balance that in the legislation. Even the 90-day portion for the immediate protection through emergency protection orders is one of those balances. The ability for a First Nation, should a revoking or extension be sought, the First Nations community itself, the Band Council, can make a representation on their cultures and laws and has the ability to make a representation as part of that, and on other applications as well, so that they can be heard if they want to have input on what or help sort out at the application.
Thank you. Time's up. Okay. Ms. Ashton?
Thank you, Madam Chair. I want to pick up on the last question raised by my colleague, Ms. Crowder, around, and I realize that you look at it based on the legislative side, but of course we have to be honest. The political end of this discussion has been very much, we constantly hear from the ministers around violence, ending violence against Aboriginal women, et cetera, and yet on so many other points, whether it's calling a national inquiry, investing into shelters, investing in housing, as was pointed out, we haven't seen any action. Now, with respect to the emergency protection orders, in an ideal world, I think we can all agree, there's no question, this measure is extremely important. But I'll bring the case of one of the communities I represent, Garden Hill First Nation. It's an isolated community on the east side of Lake Manitoba. It's about 2,500 people that live there. The RCMP lives on an island away from the main community. In freeze-up or break-up of the lake, they cannot get there very easily. In fact, one of the only ways they can get there is helicopter. This band is in third-party management. The third-party manager has cut funding to the band constables, and this program is currently actually in limbo, as in people aren't getting paid. So there's no community-based policing. The RCMP, and right now is breakup season, cannot access the community very easily. So my question is, what good is a protection order if there is no funding in policing, if there is no women's shelter, because there isn't, if there is no transition home, because there isn't, if it does take a $500 ticket to go to Winnipeg, which is the closest place somebody can go to get that kind of shelter. Those gaps aren't just gaps. We're talking about lives being on the line because that basic access simply does not exist. And we can talk in theoreticals or we can talk in practical terms. And I can tell you that the practical terms mean that emergency protection orders mean nothing when you don't have people to be able to apply them, to police the situation, and of course the service is available for the victims when the assault or the crime happens. So I'd be interested to hear your thoughts. And unfortunately we don't have the political representatives to ask about that end of things, but I'd be keen to hear where you stand.
I do know that there are some areas in programming that do help to address those situations. As you've mentioned, there is funding for emergency protection orders, and there's the Family Violence Prevention Program. There's an initiative that helps in cases of divorce, and there's other programming that is helping to address some of those situations in the north.
What kind of figures are we talking about? I mean, in the Churchill constituency, there are 22 isolated communities. 18 of them are First Nations. This is just in northern Manitoba. So, I mean, the analysis, we keep hearing about the Center of Excellence. I'm not sure that it'll be in Garden Hill. So what kind of figures are we talking about? We're talking about 663 First Nations. Many of them are isolated, remote. Could we have a breakdown on those figures and how much of that money will be allocated to remote First Nations?
I think if I may offer to the committee, you're raising a lot of points in respect of issues of funding for housing and for police services, women's shelters, and so on, and perhaps we could get back to the committee with some information about the funding levels in respect of those programs specifically.
Sure, and I would very much appreciate that background, but I also want to make sure that when we're talking about emergency protection orders saving lives, let's be clear about the lives people lead in many of these communities, because I can say for a fact that a piece of paper without anybody to implement and support the situation is certainly not going to save lives.
Is that it? Okay, Ms. Ambler?
I would argue that having a piece of paper is better than not having a piece of paper, because then at least you have a place to start. But speaking of enforcement and emergency protection orders, I'm wondering what, if any, the role of the Center of Excellence will play in that, in particular in remote First Nations communities. Will there be provisions made when, as in the example that Ms. Ashton gave, that the communities are particularly remote or under third-party management or might have some difficulties enforcing it? Is the Center of Excellence there to help, or would there be some other branch that might be able to help?
I think I would answer by saying that the Center of Excellence, again, the idea is to house it within an existing Aboriginal institution or organization who already have experience dealing with more urban communities, more prosperous communities, and remote and isolated and very challenged communities. So I think they have the skill to be able to consider very much what is the right service, what is the right type of matrimonial property law in a remote community. What kind of provisions should you provide for? And yes, the Center of Excellence should be able to provide advice on how do you handle, for example, emergency protection orders where there is not a local RCMP detachment and so on. I come back to an earlier answer that in the implementation plan going forward, our department is connected to public safety and to the RCMP. So it is on the radar screen. How can we try to make sure that the legislation is more than just paper, but actually implemented in a way that responds? I'm not going to deny the point that the committee member made. Some communities are isolated and have many challenges in terms of policing issues far beyond just matrimonial real property.
Sure. But I think what I also hear is that you're saying that the process, especially the Center of Excellence, is going to be flexible, depending on who they're dealing with. They're not going to say, here's S2, and you have to apply it this way, using this language, and implement it this way. Would that be correct?
Well, they're going to be arm's length, and I respect those institutions, but I know them, and they're very sophisticated at dealing with the great differences in circumstances of First Nations across the country. It's not one size fits all.
Right.
It's not one size fits all under this legislation. It's not one size fits all under FNLM. FNLM First Nations have different matrimonial real property laws depending where they're located to.
That's good. That's very good to know. And can you tell me a bit about the ratification process in the bill that's required? Because I think that there have been some misconceptions around that piece as well.
Certainly. I'll speak to that, Madam Chair. One of the things that I know that my colleague has mentioned, but I just want to reiterate, that the bill has to address a gap in protections and rights for women, children, and families living on reserve. It only applies to those First Nations that have a reserve community. And it is a first step in trying to address some of these problems that arise. It's not meant to be comprehensive and address them all. It's a specific purpose. And to that end, the ratification part during consultations was one of the ways that women wanted to have some form of having input or knowing about the community's laws. So that is part of from the original was included, but it has been changed in Bill S2. It actually has been lowered to set participation rate.
Thresholds for to
before
pass.
It was a double majority required, which was that we were told and we heard that it
Difficult
was
to get.
onerous,
Yes.
and that most First Nations felt they couldn't meet that high of a standard. So now it's just a set participation rate of 25% of the eligible voters who are over the age of 18 are community members, and that's to include on and off reserve members. And so it was requested so that they would be sure to have the community have input into what the community matrimonial real property law might be like. I think we had a lot of misunderstanding before with the verification process. That was removed. It was always just intended to just review the process, not the law itself. We want to reiterate that again, that the department or the minister has no say at all in reviewing, disallowing, or canceling anything in the First Nation law. It's just up to them between the government and the First Nation members.
Thank you.
Oh, sorry.
Ms. Bateman?
Thank you so much, Madam Chair, and thank you all for being with us again today. I feel I had done all the reading, but I really feel that I know the information much better now. The one piece I'd like more depth on is and if we have time, I'd love to talk about the 4 phases to your approach, which I very much appreciate. But I want to hear about the Centre of Excellence, because my understanding is that the Centre of Excellence is going to be a tool that can be accessed by all First Nations communities wanting to achieve what the 22 have already achieved. Is that the case?
Yes, I would agree that it has several elements to it. Sure. First Nations will be able to turn to the Centre of Excellence for advice on the contents of matrimonial real property laws. But more than that, they can turn for advice on the federal provisional rules. If you don't choose to make a law, what is this default federal system that the legislation calls for? So that, I think, will help First Nation governments to make a decision on the comparison. What is it that we like in this? What is it that we don't like? So if we move to develop our own law on it, what features would we want to keep, perhaps, in our own law, and what would we want to customize and make more appropriate to our community? I would fully expect that the Centre of Excellence, as an Aboriginal institution, will look across to the First Nations Land Management Resource Centre, which assists First Nations under the FNLMA in the development of all of their laws, not just matrimonial real property laws. Those laws are public. They can be obtained. So First Nations, either going through the Centre of Excellence or directly themselves, can can look at existing examples of laws. And the last point I would just make is, 6 months ago we were at, I think, 20 FNLM matrimonial real property laws. Now we're at 22. The FNLM regime is expanding, and I know that there's many of the First Nations who are in that course of adopting their own matrimonial real property laws. So if this legislation goes forward, right now the comparison factor is 22. I would expect it to go to 35 or 60 over time. There'll be more FNLM matrimonial real property laws to compare with, both for the Centre of Excellence and individual First Nations.
And go ahead if you want. Sorry.
If I may just add to something, Madam Chair, on that, just to understand the difference between those First Nations that are choosing to go under FNLMN, they are choosing to opt out of the Indian Act, with about 34 provisions that currently would apply them to related to land management. Where under Bill S2, they don't have to do that. They can develop just laws related to address the issue of matrimonial real property in their community. And that bill will stand alone. They have the ability, should they choose to have courts be able to apply their law through the provisions, or they can set up however form they want. It's up to them. It just has to be compliant, as all laws in Canada, with the Canadian Charter of Rights and Freedoms, and now, where applicable, the Canadian Human Rights Act. And I think that's important to recognize. There's a huge difference between the FNLM group. That's a part of it, as a requirement to address those gaps that aren't present. It's the same that it has to still be addressed in some form, those First Nations choosing to go under self-government agreements. That matrimonial real property has to be addressed in some way.
Oh, that's a wonderful distinction, and I wasn't aware of that distinction, so I very much appreciate you adding that. Now, just if you have a minute, your response, you were going to tell one of my colleagues an anecdote about a woman who would have been well served with this, and you got cut off. So if you would like, Ms. Green, to use my time to share that anecdote, I would very much appreciate that, or to finish that anecdote.
Oh, the one about my community, or the, I'm not sure. Okay, yeah. Related to the emergency protection orders. Yeah. Through the emergency protection orders, because you have the ability for, if you don't have permission of the applicant himself, you can seek permission to apply for emergency protection order on behalf of someone else. That could be through the court, can grant that permission. So in that instance, the daughter of the woman, fearing that something was wrong when access wasn't granted to see her mother, she could have sought that permission to seek an emergency protection order. That would have possibly helped in that situation to de-escalate.
Sorry, thank you. Time's up. I want to thank you for being with us again today, and thank you for your words of advice and understanding. We certainly appreciate the time you've taken to be with us. And I will now call for adjournment.